My apologies, Your Honor, I was working Sunday case. Why am
Well, the state was sent notice of this, Judge Waller signed.
We need to hear Mr. Shaw L's motion to substitute Judge Montgomery on a post-conviction matter, so we can call the case.
People versus Cecil Shaw, 17 CF 369.
David Rover for the state.
Sir, can you hear us?
Yes, sir. Cecil Shaw L. appropriate for summons to jurors.
All right, we're here. I was assigned to hear a motion filed by Mr. Shaw L. requesting substitution of judge for his post-conviction petition. You then filed an amended petition, is that correct, sir?
Yes, sir.
All right, and I received that. So I reviewed that. Is there anything further you want to say in your petition before I rule?
First is this a court of record?
I'm asking what argument you want to make. I'm not here to answer questions, so do you have any further argument on your petition?
So are you saying that I'm not allowed to know if this is a court of record?
You're allowed to know whatever you want to know, but I'm asking if you want to make any arguments.
Absolutely.
So go ahead.
But first I need to know if this is a court of record.
I can't answer that, so I'm giving you a chance to make your argument. So go ahead.
I demand a court of record. There's no
Anything
need,
further that you want to add to your argument?
there's no need in proceeding if this is in the court of record. I demand a court of record. And I also want to know if my family is in the Zoom courtroom.
Well, there is one other individual besides the clerk listed under Duran. I don't know who that is.
Okay. Well,
But
yes,
it's an
sir.
open courtroom. The courtroom is open. I've admitted everyone that attempted to join the Zoom meeting. So, all right.
Okay. I appreciate that. But I demand a court of record. I have to be able to.
All right. So you've made that clear. So now go ahead and make your argument on the amended petition for change of venue from judge that you filed on, that was received and filed by the clerk on January 18th of 2024.
Okay. The facts stated within the affidavit of prejudice show allowing Montgomery to continue to preside in these circumstances would be constitutionally intolerable. As he is consistently given an appearance of bias and prejudice, I maintain that his impartiality may reasonably be questioned, stated in the attached affidavit of prejudice. Montgomery has personal knowledge of disputed evidentiary facts concerning the post-conviction proceeding, and that preponderance of evidence in fact proved that the trial judge was in fact biased. The attached affidavit of prejudice affirms the rights to a fair trial was violated. I would like to go through each of the arguments listed to point to where in the record and the transcription of proceedings it can be verified.
Okay, go ahead.
May 18th, 2017, in the transcription of proceedings, during the probable cause and bail hearing was conducted in front of Montgomery without an unequivocal waiver of counsel. In the same bail hearing, May 18, 2018, Montgomery stated falsely that I was on parole for 7 cases and 3 bail forfeitures, which was totally untrue. January 30th, 2018, Stucker had alleged that she would not be available for trial and pushed it before Montgomery, as Montgomery was to hit a summary suspension to rescind my CDL. And he was present in the courtroom, and I'm not certain as to how he was able to preside over this matter when he was just a DUI judge. July 20th, 2017, Montgomery stated, but Mr. Shaw's obviously representing himself on these issues right now. So I don't know if he's going to be able to hire an attorney for that as well or not, despite an unequivocal waiver of my right to counsel. In addition to me not understanding the nature of the charges, and I maintain that it's a violation of Supreme Court Rule 401. All video conferences and Zoom calls, I was muted from objecting by Montgomery, and he would cut the screen off on me while I was speaking, and this became a common practice of Montgomery as to 17 CF 369 and 17 CF 227, and this also affected the transcripts. Some examples of the video conference where I was muted and cut off on May 2nd, 2019. In the transcripts at page 6, the majority is unintelligible, and the video was shut off while I was speaking and I was muted. My mother filed an affidavit of fact in this regard because she was trying to speak as well, because she had interest in the finances posted for bail, and wanted to explain how I missed court because of family emergencies, and she was also denied to speak. May 3rd, 2019, I was ignored, and the video was muted, and the screen was shut off on me while I was speaking. May 24th, 2019, Montgomery appointed the appointment of Dan Transier. I objected and attempted to probe, and the video was shut off as I was demanding emergency medical attention. June 14th, 2019, it was muted and shut it off. Transier falsely claimed that I gave him permission to represent me. And June 27th, all objections were muted and the screen was shut off. July 22nd, 2019, the screen was muted and shut off as I was presenting my 606C petition. And I maintain it's been the policy of Philip Montgomery's intentions to silence me from political speech and invoking my unalienable rights. Transcription of the proceeding, December 17th, 2018, page 3, lines 13 through 16, Montgomery stated clearly as to Shah L's rights. I'm not going to keep, he said, I'm not going to keep allowing Mr. Shah L to determine how we handle this case, Mr. Swirly. And I'm not just going to keep I maintain that the statement concludes that Swartley and Montgomery are clearly on the same team and intentions to deny me rights, including my rights to self-determination. All documents I filed in this matter with the clerk's office, the names and titles are just labeled correspondences and are missing. So it's almost impossible for me to look at the docket and to be able to tell exactly what was filed, because the clerk did not label any of my documents with the titles that are on them. And upon contacting the clerk's office in this regard, the clerk's office told me that this was what Montgomery had requested. I maintain that my appellation is Cecil Shaw L, and my nationality is a more American national. Montgomery would blatantly disregard this and refer to me as Cecil Shaw. It became sport to antagonize and attempt to denationalize me in the regard between Montgomery and the prosecutor Swartley in regards to my appellation and nationality. I've demanded that Montgomery place his oath of office, oath of ethics, and public hazard bonding information on file for the record. And I maintain that him not posting it is a violation of 15 United States Code, resulting in a lien, a UCC-1 affidavit of financing statement being placed on his bond in DeKalb County Corporation, at DeKalb County Recorder, and with the Recorder of Deeds in Washington, D.C. A commercial lien and full faith and credit be given to the public record in the regard.
Your Honor,
Listen on that, Mr.
I'd like to object to getting into the whole sovereign side, citizen line, liens and all the rest of it. This is about apparently a motion to substitute judge. Let's keep it on that. Let's not go down this entire diatribe. I have an emergency hearing that I'm supposed to be in for somebody who actually needs help. I don't think the court, and I surely don't think the state, is entertained by this exercise. Let's keep it on.
Oh, those are allegations he has in his motion. So
Commercial liens?
it's what he has in his motion, that the state has sent a caveat.
Motion, I don't know the service of that. But
So the lien is on the public record. The full faith and credit is given to the public record pursuant to Article 1, Section 4, Article 4, Section 1 of the U.S. Constitution. This is not about sovereign citizen, nothing. I'm indigenous. Montgomery and Robert Stucker, I maintain a scheme to have 17369 placed before Montgomery. Alleging Stucker was not available on January 30th, 2018, when she was. As I was.
Sir, I've read your motion. You're basically just reading it back to me. So what I'm asking for is if you have anything in addition to what you've put in here. Because I've reviewed it. I reviewed the first motion you filed, and then I reviewed the one that was filed on January 18th. So is there anything in addition to what you have in your motion that you want to argue?
Absolutely. So before I stated that I wanted to go through each one to point out in the transcription and the dates that these.
I don't see that you attached any of the transcripts to your motion.
Excuse me?
You said you want to go through the transcription, but I don't see any exhibits with the transcripts of these hearings attached to your motion.
No, I couldn't make copies, and the transcriptions are missing. Between being down here, my transcripts come up missing, so I'm actually going off my personal records that I have that from previous affidavits that I filed, because I actually have to write the clerk here to actually try to get another copy of the transcripts, and I'm just referencing. Yeah, I'm actually verbatim stating what was stated in the transcripts.
From your memory? Is that what you're saying?
No, not from my memory, from what I have wrote down from previous petitions I may have filed. There's quoted.
All right.
May I request that the clerk issue
So-
email to the chief judge when I disclosure?
Sure.
Temporary. Thank you.
Montgomery forced counsel to represent me despite my Sixth Amendment right to be my own counsel or to have counsel of my choosing, and falsely asserted that I was being disruptive in the courtroom for merely refusing to leave, exercising my right to political speech and requesting to know the next court date, December 2018. And the next court date, I actually spoke in regards to a matter that was in Montgomery's courtroom where he refused to recuse himself. Because he refused to recuse himself when the defendant was just at his Christmas party and was accused of a sexual crime, and he developed like an ill will towards me in regards to me speaking in the regard. Montgomery refused to instruct Scott Swarley to produce a definite statement of bona fide allegation of jurisdiction upon my Sixth Amendment, Article 1, Section 8, Clause 17 demand, August 16, 2019. I was not provided the nature of the cause of the charges upon my demand. I did not understand the charges. There was no plea entered on it for the record. I demanded a verified affidavit from a corpus delicti or injured party. There was entirely no discovery provided. I was given an excessive bail imposed solely just to retain me in custody, despite me making special appearances for almost 2 years straight. Evidence was lost. No discovery was again provided. My family's bail money was just taken off both cases. They wasn't allowed to speak in regards to their finance. I was beat in DeKalb County, attacked May 6th. And I'm currently still injured from this. I was oppressed and I requested medical attention. The writ could be issued by Montgomery and was denied, resulting in further injury of my lower lumbar. I maintain that this can be exhibited. These documents that I filed are on the record. It was filed June 27, page 4. June 27th, and I maintain that he was aware. Montgomery's ex parte communication between himself and Mr. Swartley during jury selection process. He was covering his hand like this over his head and literally whispering to the prosecutor right before witnesses. And I have the affidavits on fact to verify this as well. Literally whispering to the prosecutor, I can't even make this up, whispering to the prosecutor before the jurors, potential jurors, and witnesses. Also, ex parte communication between a federal prosecutor who's a member of Philip Montgomery's church, Ms. Erin Duffy, juror number 59, probably a 3 to 4 minute conversation off the record before us and the jurors. And then February 24th.
So was she one of the jurors then?
She was one of the jurors.
Was she
Absolutely.
selected as a juror for your trial?
Absolutely.
She was one of the 12 jurors?
She was one of the 12 jurors, but Montgomery denied that this even occurred, and it's clearly within the transcripts, because when I asked why she was whispering, he stated it was going to be brought to the record. So therefore, what he was talking about was clearly off the record, and it presented a prejudice towards the jurors because they may have taken her being on the jury of some type of value.
Your Honor, I'm not in possession of any of these materials, but there are affidavits in there that are demonstrating that there was ex parte communications between the state and the judge in this matter.
Not attached to the motion.
Okay, well, I would object in sitting here and making such assertions, especially since you did say affidavits and there are none. I think that if he's going to make such assertions, then we have the right to review that material he is asserting for. Again, I do not know that we were ever given those things. I don't know anything in this matter.
Well, I believe.
I mean, your office prepared the writ that got Mr. Shaw here today, so I'm not sure how you weren't aware of it. Right? The state's attorney's office. Right. I'm just saying that it was.
As far as our office, we can speak as to other people's interaction, people speaking in court, doing that's where he's making assertions as to Scott Shortly, I think Scott Shortly should have the ability to defend himself.
Well, this is a motion to substitute Judge Montgomery, so I just want to get there.
That she's asserting things as to Scott Shortly, who's also asserting commercial limits. So, if this is going to be a free-for-all, Mr. Back Petition, then I think we would address it.
All right. The affidavits that you're referring to, Mr. Shiles, you have not filed those in connection with your motion, correct?
They are on file. They're on file in DeKalb County. I referenced them, but I did not attach them to the motion because I've had a problem down here in the facility where transcripts came up missing, and also obtaining copies to be able to file when the trial court due to staff shortages and lockdowns and whatnot. It's been difficult to access the courts, but I can prepare copies. I would, if it's necessary, I could prepare all the copies and documentation to attach to the affidavit of prejudice.
Well, that was to be done at the time you filed the motion and was set for hearing. So is there any other, just a moment, Mr. Burrow. Is there, as I said, I've reviewed the motion. You are continuing just to reassert what you've alleged in the motion in your affidavit. So it doesn't sound I mean, if you wanted to present those affidavits, this would have been the time.
So how could I have the affidavits, how could I present them right now? If I'm not in the courtroom?
Either of us is your attorney, you can advise this. Your Honor, I'd ask Mr. Shortley to come down. He's in our closing.
Well, I mean, at this point, so just give me a proffer, sir, of what you say these affidavits say. You're saying that, and who's the affidavit from?
The affidavit is from, well, the majority of them are from myself.
Okay.
And of course, one is from my mother, one is from witnesses that were in the courtroom bearing witness to these
What are
atrocities.
their names?
Duran Shaw and Tamara McWilliams, Celia Shaw, and myself. And the majority of this is also referenced within the transcription of the proceedings.
All right.
I believe the state has seen transcripts around this, for the judge's representations.
All right. Well, I'll note your objection. So, Mr. Shaw, I considered your motion. When you file a post-conviction petition, there is no statute that applies for substitution of judge. And it's presumed that the judge who presided over the criminal trial will hear the post-conviction petition unless the judge is substantially prejudiced. To establish substantial prejudice, a defendant must demonstrate that the judge holds animosity, hostility, ill will or distrust or prejudice, predilections or arbitrariness. Only under the most extreme circumstances is disqualification on the basis of bias or prejudice constitutionally required. Now, if there is an appearance of prejudice, the judge must recuse himself from post-conviction proceedings, but the judge himself is in the best position to determine whether he can be impartial. And it is presumed that judges will be impartial, and however, they must ultimately determine whether they can hold the balance nice and clear and true between the state and the accused. And disqualifying a judge for cause is not to be lightly made. And when the circumstances, as here, do not call for mandatory recusal or independent judicial evaluation of claims of prejudice as required under the criminal statute in section 114-5B, trial judges are in the best position to determine whether they can be impartial. And as I said, the defendant must show something more than simply that the judge presided over the trial and made rulings against the defendant. What you've alleged in your motion, I don't find to rise to the level to show that that Judge Montgomery cannot be fair and impartial in this case. As I said, only under the most extreme cases is disqualification on the basis of bias or prejudice constitutionally required.
So this court
Just a moment, I'm not done. our United States Supreme Court has held that a judge's prior rulings in the case rarely, if ever, can form the basis for a recusal motion. And many of the things that you complain about in the motion to substitute Judge Montgomery are disagreeing with his rulings. You are indicating that he didn't do things that you wanted him to do, that he's not required to do under the law. For example, paragraph 8, you indicate that he refused to place his oath of office, oath of ethics, and public hazard bonding information on and for the record, resulting in a commercial lien affidavit financing statement being placed on DeKalb County Corporation. That doesn't even, that does not apply in Illinois. That is not any legal requirement that a judge do that. So the prejudice that you're alleging, part of it is based on things that you're saying that he didn't do, that there is no basis in law to require that he do. You also indicate that he failed to recognize the United Nations Declaration on the Rights of Indigenous Peoples. That doesn't apply either. He failed to perform under de jure law as ordered by Article 3, Consular Court Jurisdiction, as pursuant to Public Law 8, Statute 484, Sections 100 through 104. That's something else that's not required. So the amended petition that you have filed does not rise to the level for me to find that disqualification on the basis of prejudice or bias is constitutionally required, and therefore your motion or petition to substitute Judge Montgomery is denied for all those reasons I've just stated.
Objection. So
I'm going to set the case back before Judge Montgomery. I did see that you filed a motion to
objection. I have something to say.
I've made my ruling. I gave you the opportunity to make the argument.
I have an objection. Is it your lawful determination that my affidavit of fact is not true? That's attached to the motion?
I made my ruling. I'm not going to be subject to a question and answer session about the basis for the ruling. I've made the ruling. It's on the record. So you can.
So what is your lawful reasoning for your ruling?
I just gave all my lawful reasons for the ruling, sir. So I'm setting this case back before Judge Montgomery for status.
You have not stated, sir, you have not stated any law. What law have you stated?
Okay.
What law? Seriously, full faith and credit is given to the public record. Article 1, Section 10 gives me the right to unlimited right to contract. What law have you stated? In fact, which jurisdiction of laws is this court operating under? I don't understand the nature of what law you're speaking in regards to.
I'm going to set your case for February 13th at 10:30 before Judge Montgomery in courtroom 210. The state will prepare a video writ. Sir, I made my ruling. I stated the law that I was relying on.
Sir,
Law of the state of Illinois and the United States. I cited the United States.
Which criminal jurisdiction? Which criminal jurisdiction are you operating under? As pursuant to the laws of Illinois State Republic, as pursuant to the U.S. Constitution.
I've made my ruling. Your next court date is February 13th at 10:30.
Based off what ruling did you base your facts on? Are these facts in law in front of you?
I based my ruling on the petition. So that's all for today, sir. Your next court date is February 13th.
So is the affidavit a fact? Not true?
I don't have any further comment on my ruling. I've stated it for the record. That's all for today.
You have stated no law in regards to your ruling.
I'm ending, the record will show that I'm ending the Zoom meeting. I've
What,
indicated that I made
what,
my ruling.
what law,
I'm not
what law?
continuing.
Where's the law?
So the meeting is
Where's the
ending,
law?
sir.
Passed.